Thank you for joining us for this ethics instructor training. I'm Alex Torres, the new manager of continuing education and experience. I'm joined by Leo Rajeski, our general counsel. And I see a question right away here about, is there a number you can dial in for the audio? The answer is no. We're actually having the audio done through your computer directly. During this presentation, we will give a comprehensive review of the new code and standards as it is to be presented and answer your questions at the end of the presentation. Please feel free to type in your questions throughout the presentation in the text box. And we will go through those questions at the end of the presentation. Leo will now take you through the ethics presentation.
Good afternoon, everybody. I see some friendly faces who are participating in this conference. So welcome to this Ethics CE instructor training. We're going to spend about an hour to hour and a half going through the new Ethics CE program. I hope that what we go through today is informative. I encourage you, prior to delivering the training, to go through the slide deck, to be prepared, to think about how you can structure delivering the content as well as blending in some of the vignettes that are optional for you to use. I think what we've heard and what we've found so far is that the instructors have liked blending in some of these case studies and introducing them in their program. It's made it just more interesting for the audience, a more effective delivery of the content. And so those are available to you to figure out how to blend in today. What I'm going to do is go through the slide deck and talk to you about the code and standards. If after this presentation or otherwise you have any questions about the content, you'd like to reach out, you can find me on the website, but my telephone number is 202-379-2230, and I'd be happy to work with you to try and work with you to think through the issues that you'd like to raise. All right, so why don't we talk about the learning objectives for the program. We've developed 5 learning objectives for the Ethics CE program, and as you all know as experienced instructors, the learning objectives are really important because they frame the content that you're going to deliver, and this is what you're hoping to achieve. This is what you would like the audience to know by the time you're done. So first of all, identify the structure and content of the revised code and standards, including the significant changes and how the changes affect CFP professionals. I think this is an issue that's on a lot of people's minds these days as we move closer towards the October 1st, 2019 effective date of the code and standards. So knowing about the structure and content and the changes and what those changes mean, I think are just important points for all CFP professionals. So the most significant change in the code and standards is the expansion of the application of CFP Board's fiduciary duty. So one of the objectives is to be able to act in accordance with that duty. As you know, CFP Board historically has had practice standards for the financial planning process. The code and standards updates those practice standards. There's been a reordering in some places, as well as a change in the number of them. You may have heard we've gone from 6 steps to 7 steps. So one of the goals is to be able to apply the practice standards when providing financial planning. The 4th learning objective is to recognize situations when specific information must be provided to a client. This is an area of the standards, it's section A10, that talks about providing information to a client. What you'll find there are that the requirements are very, very similar to those that currently exist. So if you're familiar with those, that one should probably be an easy one for you. Next is, conflicts. So the CFP Board's code and standards sets forth a framework for dealing with contents. It's a choice, effectively. You can avoid them. That's something you can do. A CFP professional can avoid the conflicts of interest. But if you don't avoid them, you have to fully disclose and manage them. So the learning objective here starts out with the threshold question of, do I have a conflict of interest? You need to be able to recognize when you have it and then either avoid or fully disclose and manage that conflict. All right, so let's begin by going through the structure, content, and significant changes. This is learning objective 1. So first and foremost, there are some significant changes to the content of the revised code and standards. There's a new structure and a new organization. We used to have 4 different documents. They've been consolidated into one. And the standards themselves present duties to clients, to firms and subordinates, and the CFP board. So the most significant changes to the content are on the screen. There are other changes, but these are the ones we consider to be the most significant. One is a change that I mentioned a few minutes ago. It's that expanded application of the fiduciary duty. If you've read the trade press about this, you'll know that this is the change most to focus on. The industry itself is very much immersed in a conversation right now about fiduciary, about best interests, when that standard should apply, how it should apply. CFP Board came out in March of 2018 with the final version of its standards that will go into effect October 1, 2019, and expanded the application of that fiduciary duty. We also have updated duties to clients, a revised definition of financial planning, modernized practice standards, a new process for bankruptcy. There's some changes on the bankruptcy front, as well as some enhanced requirements for reporting. Okay, let's walk through some of these. With respect to the structure, I mentioned that we've consolidated some of the structure. Before we had, these are the standards that are in effect until September 30th. We had different documents. We had a Code of Ethics and Professional Responsibility, was a separate document from the Rules of Conduct, which is a separate document from our Financial Planning Practice Standards, and of course the terminology section itself was a different document. And the consequences of having different documents are probably fairly obvious to you, but to spell them out, one of those is that those documents needed to speak to each other, and they needed to stand alone. So at times it required additional content, like in the Code of Ethics. We didn't just list the principles of the Code of Ethics, but we also explained what they meant using operative language. The practice standards and the rules of conduct had provisions that addressed the same general subject matter, and you would have to read both of them in some circumstances to find out the standards that apply in similar areas. So the revised standards have one document. It's organized with a preamble. The preamble is short. It's in short intentionally so. The idea of the preamble is to set the stage for everything that follows. It's only 3 or 4 sentences, so why don't I read it to you? I think this might help. CFP Board's Code of Ethics and Standard of Conduct reflects the commitment that all CFP professionals make to high standards of competency and ethics. The CFP Board's Code and Standards benefits and protects the public, provides standards for delivering financial planning, and advances financial planning as a distinct and valuable profession. Compliance with the Code and Standards is a requirement of CFP certification that is critical to the integrity of the CFP marks. Violations of the Code and Standards may subject the CFP professional to discipline. I think that preamble really provides the context for what the Code and Standards are, how they help, and what the consequences of not following them are. So following that, you have the Code of Ethics. Again, this is all in one document. The Code of Ethics set forth the principles without the operative language. Everything that's set forth as a principle in the Code of Ethics has a standard in the Standards of Conduct that relates to it. So, for example, competence is an element of the Code of Ethics. Well, we have a duty of competence in the Standards of Conduct that provides greater detail about what that means. And then, of course, the practice standards for the financial planning process and a glossary of terms. Now, where a term is used in multiple places, you'll find it in the glossary. Where it's used only once, oftentimes you'll find it in the standard where it emerges. That was a judgment call that we made that we thought would help make the standards more digestible. So here's the Code of Ethics. I already mentioned competence, which is number 1. So what did we start off with? We started with act with honesty, integrity, competence, and diligence. Those are important elements of what it means to be a CFP professional. The rest is on the screen for you, and I'm not going to read it to you, but I do want to point out that we've been going on the road holding public forums. We did this before we started working on revising the standards. We did it during those revisions, and we've done it now since then to work on guidance resources for CFP professionals. We've had nearly 30 public forums along the way, meeting with thousands of CFP professionals. And what we've heard from many of them is that they have a printout of the Code of Ethics as it currently exists that they display on their wall. And that was told to us by quite a few people during those forums, that that's one way they help educate clients about what it means to work as a CFP professional. So we now have available, it's on our website, I believe, a Code of Ethics poster. That's something you might want to let those who are enrolled in your program know, that they can go to the website, they can print out the Code of Ethics poster. I believe it can be ordered. And we know that some already have done that and are framing it in their offices and putting it up on the walls. So that's one of the points you may want to mention during your class. Okay, Standards of Conduct has 6 sections. The duties owed to clients. Well, that's first and foremost, right? CFP professionals providing services to clients. That's the first section. Financial planning and application of the practice standards. So here is where financial planning is defined, and here is when we say that a CFP professional is required to provide financial planning. CFP Board is the Certified Financial Planner Board of Standards, so as you know, financial planning is really important to us. That section is a really important section of the Code of Standards. The practice standards themselves, again, we'll go through a little bit more, but there's been some revisions there. That's one of the 6 sections. Circumvention, what the heck is that? Circumvention is just a standard, it's off on its own, that says you can't do indirectly what the Code and Standards prohibits you from doing directly. In other words, if you're trying to game the system somehow by getting around it, you can't do that because of the circumvention standard. All right, duties owed to firms and subordinates. We had this before, we have it now. The CFP professional does have duties to their firm. They do have duties to the people who are working for them. There's a section that addresses that. And then finally, duties owed to CFP Board. This is really important. Some of the elements here are not engaging in conduct that's unbecoming of a CFP professional. So, for example, if you have a felony conviction, for example, that would violate a duty of the CFP Board. In addition, every now and then a CFP professional, notwithstanding the commitment that they made to high standards of competency and ethics, they run afoul of those standards. And so it's important for CFP Board to be aware of when that happens so that CFP Board can take action, really, to protect the marks for the benefit of others who are doing the right thing, as well as for credibility of the public. So that's all set forth in that duties owed to CFP Board section. Let's walk through some of the duties owed to clients. These are duties that should be understandable to you. A lot of them are already spelled out in the current standards, and to be honest, they just make sense. So if you think about it, integrity, a duty of integrity is really important if you're a CFP professional. And so what does that mean? It's, being honest and candid. Don't subordinate, that to your personal gain and advantage. CFP Board also has the standard anti-fraud language that's in the federal securities laws as well as many of the state securities laws. That language, we use the same language that exists in the regulatory structure so that our standards would be consistent with it. We would look to interpretations of federal and state law in applying that standard. So competence. The standard for competence was expanded a bit here in the Code and Standards. So what does competency mean? It means relevant knowledge and skill. And what do you do with competence? What is how does that work? So you may already have the competence. Maybe a client comes to you with an issue and you're already competent to handle it. Well, then that's rather straightforward, right? But what if you don't? What if it's something you have to figure out? So you have choices. You can gain the competence, right? So you can figure it out. Or you can obtain assistance from somebody else. Another choice is to limit or terminate your engagement, with respect to that area where you are not competent. And then you're not required to, but one choice here is also to refer the client to somebody else who is able to help them with their issue. So that's a competency standard. And diligence, well, this is kind of textbook. Diligence means, being timely and thorough, responding to the client requests in that manner. That's diligence. Let's continue to walk through these. So objectivity, this is an important one. So objectivity means exercising professional judgment that is not subordinated to something else. You need to avoid considerations that could compromise objectivity. Here, CFP Board adopted a principles-based standard as opposed to a specific detailed rule. So, for example, CFP Board could have talked about the amount of dollar value of gifts you're able to accept and those sorts of things, or maybe even had a prohibition or dealt with sales contests in some way. The standards don't do that. They have a principles-based standard that says that you have to avoid considerations that could compromise your objectivity. Professionalism, this is, if you're a professional acting the way that you should be, you'd be following this standard fairly easily. It's treating clients and others with dignity, courtesy, and respect. It's what we expect of CFP professionals. Client communications. So that's an important one when you're communicating with the client. What is it that you need to do? Well, so first of all, with client communications, there's a requirement to provide accurate information to the client, right? You have to give them the accurate information. You have to do it in accordance with the engagement and in response to reasonable client requests in a manner and format that the client reasonably may be expected to understand, right? So that's client communications, the duties when communicating with the client. Here's an important one: comply with the law. Some people have asked us, the CFP Board standards inconsistent with the law? Well, that's the answer is no, and it's technically impossible because CFP Board standards say that you have to comply with the law. We bake that in. That's an obligation of the CFP professional to comply with the law. What people often refer to is, the fact that CFP Board standards may be higher or more rigorous than what the law requires. That certainly doesn't make them inconsistent with the law. It just means that they're, in some cases, depending upon the regulatory structure in which you operate, in some cases it may be that they're just higher standards. Okay. Let's move on now to confidentiality and privacy. So this is an important standard, and so the CFP Board canvassed the area of confidentiality and privacy and came forward with a standard that we felt would be useful for CFP professionals. So a CFP professional must keep confidential and may not disclose any non-public personal information about any prospective client or former client, except that there's certain places, circumstances where a CFP professional may disclose that information. So for ordinary business purposes, you can do it with the client's consent. You can do it to your firm or another person with whom you're providing services, who's has a need for the information to perform the services. You do it to provide information to the CFP professional's attorneys, accountants, and auditors. And you can do it to a person acting in a representative capacity on behalf of the client. For legal and enforcement purposes, you can also disclose to law enforcement authorities to comply with the law. If there's a civil suit or regulatory investigation and there's a subpoena or a summons, then that's okay. If there's allegations of wrongdoing made by a government authority, then you can provide the information that's necessary. If there's a civil claim, you can again use information that's necessary in your defense. The CFP Board, you can provide it, if there's an investigation or adjudication going on. If you're providing information to professional organizations that are assessing the CFP professional's compliance with professional standards, you can comply with it then. There is a safe harbor that we have. The safe harbor says that you're deemed to comply with the section if your firm is subject to and you as a CFP professional comply with Regulation SP under the federal security laws, or it could be a substantially equivalent federal state law or rule. For example, if you're in the banking business channel, they have different privacy laws that apply in that circumstances. And then we also have a standard that talks about adopting and implementing policies regarding the handling of the information and providing a copy of a document of that. Again, Reg SP is a standard that requires that in any event. And then you have to take steps to protect the security of the information. So that's confidentiality and privacy. We also have a standard for technology. So as you know, technology is becoming even more important. Every year it becomes more important, this use of technology. So what does a CFP professional have to do when selecting, using, and recommending technology? There's a standard for this. It's set forth in A14. You'll see the word reasonable here a lot. The reason for that is that, as you know, technology changes so frequently that our standard must survive through time. So, this standard talks about what's reasonable. That's, given the technology that's available at the time. We have to exercise reasonable care and judgment in selecting, using, and recommending technology, have a reasonable level of understanding of the assumptions and outcomes of the technology, and have a reasonable basis for believing that the technology produces reliable, objective, and appropriate outcomes. All right, so before we get on compensation, I'm looking at the Q&A screen. Is everybody still alive and awake out there? If you're alive and awake, all right, we got a couple hands out there. Good. Anybody watch the basketball game last night and stay up late for that? I happen to live, we call it the Commonwealth of Virginia. It's not, it's how they do it in Virginia. And in these parts around here, people are pretty happy with the outcome, but that's probably not the case all around the country. All right, so let's work our way through compensation. So compensation representation, we get asked this every now and then. The CFP Board, the organization for fee-only planners. You have to be fee-only to be a CFP professional. It's a pretty easy answer for me. I can do it in one word. The answer is no. Most CFP professionals earn sales-related compensation of one form or the other. And CFP Board itself is compensation neutral. We believe before, we believe now, and I dare to say I believe we always will believe that a CFP professional can act in the best interest of the client no matter how they're compensated. No matter what the business channel is, the CFP professional can act in the best interest of the client and do the right thing. But when it comes to compensation method, the issue that we have is being accurate. If a client is looking for a specific type of financial planner, then it's important that the communications that are being used are accurate. So with the compensation method, we have some key terms and concepts: fee-only and fee-based, sales-related compensation, related party compensation, and representations by a CFP professional's firm. So fee-only is a defined term. There's a lot of language that helps explain what that means, but somebody who's fee-only does not receive sales-related compensation. We describe in the standard what sales-related compensation is. And it's not just the CFP professional, it's a CFP professional, the CFP professional's firm, and a related party whose work is in connection with the work of that CFP professional, the CFP professional's firm. These are all spelled out in detail in the code and standards, so I encourage you to take a look at that. A new point here is that we now talk about fee-based. So fee-based is a term that's often used. I'm looking at the Q&A here. Does anybody believe that consumers know what fee-based means? Take a look at that and tell me in this Q&A response. Do you think the consumers know what fee-based means? So Margaret weighed in and said, no, they don't. Ralph says, not unless explained. Dennis, hello, Dennis. Consumers have no idea. Stephen Lewis, probably not. Jason, They hear the fee and not all. Jennifer, not really. So your reaction is very similar to what CFP Board concluded in writing the standards. And the truth is we had a choice. We had to decide what to do about it. You see the conclusion here. What we decided to do is to say that if you use the term fee-based, what you have to do is two things. You can't use it in a way that suggests that you're fee-only, right? So you can't do it in a misleading way. And secondly, you must clearly state either that you and your firm earn fees and commissions or that you're not fee-only. In other words, CFP Board does not ban the term fee-based. We thought that was the wrong way to go. As you know, CFP Board, a lot of people are certified by CFP Board, but not everybody is. So that word is going to be used by others. If we banned it, it wouldn't stop the problem. And so what the code and standards do is try to provide a way to help with the problem by educating folks about what fee-based means. You know, the board of directors at CFP Board had to make a value judgment, and that's how they came out. So looking at the rest of the compensation standard, we talk about what it means to be a related party, and we talk about if you're at a firm and the firm is discussing its compensation method in a manner that's inconsistent with CFP Board standards, then what you have to do depends upon whether or not you control the firm. If you control the firm, well, then you have to have that firm speak in a way that's consistent with our standards. And if you don't control the firm, then what you need to do effectively is tell your clients that you're not fee-only. That's the approach that CFP Board adopted here. Okay, so the fee-only application, so the question is, are you earning sales-related compensation? If the answer is yes, you're not fee-only. How about your firm? If the answer is yes, not fee-only. Is there a related party earning sales-related compensation? That's a question. If the answer is yes, then the question is that related party compensation in connection with the services you and your firm are providing? If the answer is yes to that third question there, then you cannot say you're fee-only. That's the short version for how the standard works. Let's talk about another new standard, working with additional persons. So who out there, again, the Q&A box would help with this, who out there provides services to a client and they're working with additional persons when they're doing it? It could be an estate planning lawyer, it could be a tax, it could be someone doing tax, it could be somebody else. Does anybody do that? I'm hearing responses back. There's some caveats for who they might be, but Chris, Ralph, Margaret, Jennifer, they're all saying yes. We're working with others. So CFP Board developed a standard for, what do you do when you're working with others? So first of all, there's a standard that talks about what do you do when you're referring the client to somebody else? Having a reasonable basis to believe, based upon the person's reputation, experience, and qualifications, that they can handle the engagement. The second one is disclose to the client if you're getting compensated for that referral. And then if you're actually engaging that person, so you're doing the contract to engage them, you have to exercise reasonable care to protect their interest. Classic example of that is you bring in somebody else, they're working with you to provide services to the client's giving you confidential information, well then you have to get that other professional to agree to keep that information confidential. That's what you would do, to exercise reasonable care in that circumstance. All right, that's the duties when engaging. So what about when you're working with additional persons? Hopefully this standard will make sense to you. One of the basic things you have to do is to know what each person is going to do. Has anybody ever been in a situation where there are multiple people working on something and something slipped through the cracks because not everybody knew who was doing what? So in other words, one person thought they were doing it, the other person thought the other person was doing it. I see a yes coming in on that one. Well, with the standard, the first part of the standard says communicate with the other provider about the scope of the services and the allocation of responsibilities. So make sure everybody knows what they're doing. And the second one is informing the client in a timely manner if you have a reasonable basis to believe that the other provider's services were not performed in accordance with the scope of services to be provided and the allocation of responsibility. So If you see it, know that what the other person's doing isn't right, you have a duty to tell the client. That's working with additional persons. So what about duties owed to firm and subordinates? Let's talk about that briefly. Here you have to use reasonable care when supervising individuals. The firm may have policies and procedures, so there's a duty to comply with the lawful objectives of the firm. And then if there's public discipline, there's a duty to provide notice of that. Okay. All right, let's talk now about the duties owed to CFP Board. So there's several here. So first of all, it's avoiding adverse conduct. That makes sense. Reporting incidents of apparent adverse conduct within 30 days. The code standards is a pretty long list of what that might be. Provide a narrative statement. That's, tell CFP Board what happened. Explain the facts. Then cooperate with CFP Board in its investigation. And also, CFP Board has the terms and conditions of certification and license. That's the agreement that all CFP professionals have with CFP Board. There's a duty to follow that agreement. All right, so let's do a quick review. This is the longest learning objective because, this is kind of the data dump on the new standards. There's a new structure and organization of the code and standards. There are duties to clients, duties to firms and subordinates, and duties to CFP Board. That's the basic structure. If you go through the standards, you can think about it with that framework in mind. So when you're delivering this, there's polling questions for you. We also have 4 vignettes. That's a fancy, I think, French way of saying case studies. I don't know who put that together. Was it Adam August or somebody else? I don't know. But it's case studies. There's 4 of them. I recommend you take a look at them. Make your own judgment about which one you think resonates with you that you would like to deliver, and find a way during your program to inject a case study to make it more interesting and entertaining for the group and informative, and use those as part of your presentation. Okay, why don't we turn now to learning objective 2. This is the fiduciary duty. Fiduciary, it's a 5-syllable word. The fiduciary duty, that's the next learning objective to know about that. All right, the fiduciary duty, CFP Board's fiduciary duty is drawn from the common law of fiduciaries. This is, it's intended to be interpreted in a manner that's consistent with how it's interpreted under the Advisors Act. It's another way that CFP Board's code and standards is intended to be consistent with the existing regulatory structure. So with that in mind, CFP Board's fiduciary duty has a duty of loyalty, a duty of care, and a duty to follow client instructions. In the common law, the duty to follow client instructions has a different name. Does anybody know what that is in the Q&A box? What the duty to follow client instructions typically is called in the common law? All right, it's often called the duty of obedience. And we're at CFP Board, we're a kinder, gentler organization. We thought that we could say it in a slightly different way than talking about obedience. So the Board of Directors used this duty to follow client instructions. It's effectively a basic principle of agency law. You're working for and on behalf of your client. If the client tells you they want you to do something, you're working with them. It's possible, if you follow the right process, for you to get out of the engagement if that makes you uncomfortable. But ultimately, the client gets to decide what to do. All right. So those are the 3 duties within the fiduciary duty. Our fiduciary duty at CFP Board applies to all financial advice to a client. Those are important words, financial advice and client. They're defined, but that's who it applies to. And you should know that the definition of financial advice, which is in the glossary, is quite broad. All right, let's talk about the duty of loyalty. The duty of loyalty is a very important duty of a CFP professional. It means placing the interest of the client above the interest of the CFP professional and the CFP professional's firm. Another element of the duty of loyalty, we talked about it before, and it's actually the fifth learning objective on its own, is this idea of conflicts. It's avoid the conflicts or fully disclose material conflicts of interest to the client, obtain the client's informed consent, and properly manage the conflict. And finally, it's acting without regard to the financial or other interests of the CFP professional, the CFP professional's firm, or any other individual or entity other than the client. And at CFP Board, what that means, it's just another way of saying that a CFP professional acting under a conflict of interest continues to have a duty to act in the best interest of the client and to place the client's interest above the CFP professionals. The duty of care, again, this duty of care, I think you'll find it's very consistent with the common law. It's yet to act with the care, skill, prudence, and diligence that a prudent professional would exercise in light of the client's goals, risk tolerance objectives, and financial and personal circumstances. The duty to follow client instructions, well, where is a client giving the best instruction? That's the terms of the engagement. That's the agreement where the client's telling you what they want you to do, as well as following the reasonable and lawful directions of the client. If somebody's telling you to do something that's not lawful, well, you just don't have to do it. Okay, so again, we mentioned all financial advice. That's when the duty applies. At all times when providing financial advice to a client. This is more expansive than when providing financial planning. So when you're providing financial advice, that's more expansive when you're providing financial planning, and that's because financial planning is a kind of financial advice, but there's other kind of financial advice that's not financial planning. All right, so financial advice, here it is. This is the definition. It's a communication that, based on its content, context, and presentation, would reasonably be viewed as a recommendation that the client take a particular course of action with respect to 4 different things. These are things that should resonate with you: developing or implementing a financial plan, purchasing, holding, gifting, or selling financial assets, investment policies, strategies, portfolio composition, asset management, and also the selection or retention of other professionals. So if you're giving the client advice about selecting somebody else, that's financial advice according to CFP Board. And then finally, discretion is broken out separately because advice is something you give somebody else to do. Discretion is when you actually do it on behalf of the client. It operates in the end in the same way. So the exercise of discretionary authority is the component of financial advice. All right, so we went through the fiduciary duty fairly quickly, but here it is: the duty of loyalty, duty of care, the duty to follow client instructions, otherwise known as obedience, applies to all financial advice and is broadly defined. You may be asked during your presentation, is CFP Board providing guidance on this? The answer is yes. We've been working on that. We've issued some FAQs. We have other resources on our website. A website you may want to jot down. We post it typically right on the landing page of our website, but it's cfp.net/code. That's where you can go to find a lot of information about guidance resources that CFP Board already has created. So you'll find it all there. You should know that we're planning on releasing in the next couple of weeks. I'll have to talk to Alex to make sure this is going to work out. But a roadmap that provides an overview of the code and standards that will be available to all CFP professionals. And we're also working on these case studies like the ones we provided to you. We're actually working on ones that will release to the public. The timing on that is still TBD, but we're not far away from having those out, and those will be useful for people. You might want to point out to when you're providing your instruction, let everybody know that's a place you can go to at CFP Board to to find those types of guidance resources. So again, we have some vignettes for you. We have polling questions when you're delivering the content. Encourage you to look at these materials, use them. Hopefully they'll be helpful. So far, our feedback has been positive about them. People have enjoyed using them, and I hope you have the same experience. Okay. Let's turn to learning objective 3, applying the practice standards. So practice standards are really important to CFP Board. As you know, the main areas here, we have an updated financial planning definition. We have a revised standard for determining whether the practice standards will apply. There are options that are available to a CFP professional when they're required to comply with the practice standards, but the client does not want to engage for financial planning. There's a documentation standard that applies, as well as an update to the steps in the financial planning process. So let's talk about the definition first. There's now 30 words to this definition, each of which were examined deliberatively. Financial planning is a collaborative process. It helps maximize a client's potential for meeting life goals through financial advice that integrates relevant elements of the client's personal and financial circumstances. CFP Board developed a document. We call it the commentary. The commentary contains comments to the code and standards. This is another document you may want to be aware of. And the reason is somebody may ask you, why did we pick these words for the definition? Well, if you look in the commentary, there's about a whole page that goes through each clause of that sentence and explains why those words were chosen. Okay, the practice standards, when do they apply? So the first one should be obvious. It's when you agree to provide or you provide financial planning. That's when the practice standards apply. The second one is you agree to provide or provide financial advice that requires integration of relevant elements to act in the client's best interest. So let's look at this definition. Financial planning is a collaborative process that helps maximize a client's potential for meeting life goals through financial advice that integrates relevant elements of the client's personal and financial circumstances. So this third or second bullet here just means if you have an agreement that requires you to do that, but you don't use the words financial planning, well, you're still required to apply the practice standards. And then finally, does the client have a reasonable basis to believe that the CFP professional will provide or has provided financial planning? It used to be the case that, if the client had a belief, it was a factor to be thinking about in making that determination. But what if the client is just unreasonable? Well, if the client's unreasonable, it shouldn't matter what their view is. But if the client has a reasonable basis to have that belief, well, that in and of itself is enough to require the practice standards to apply. So that's an independent way that the practice standards can apply. So when is integration required? When is this financial planning integration required? We have factors. This is an update to the current standards. The factors look at the number of relevant elements that are being touched by the advice, the portion and amount of the client's assets that are affected, the length of time the client's circumstances may be affected, the effect on exposure to risk, and the barriers to modification of the financial advice. Overall, these factors are fundamentally the same as they've been before. Hopefully, what you'll find is that they've just been written a little bit better, a little more clearly, and a little more precisely. There's a standard for the CFP Board's evaluation of this. So if CFP Board alleges a practice standards violation and the CFP professional denies the allegations, then the CFP professional has the burden of demonstrating that financial planning was not required. This is the CFP Board evaluation standard. All right, what if the client doesn't want financial planning? Those of you in the audience, have you ever worked with a client who you thought would benefit from financial planning, but they say that they didn't want it? Has that ever happened to you? All right, Tim, Ralph, Jason, Charlton. I'm seeing some yeses out there. So, we agreed in writing the standards, we looked at that. We heard from CFP professionals that that's something that happens. What are you supposed to do if the client doesn't want to engage you for financial planning? Should we send the client to somebody who's not a CFP professional? Well, what's going to happen then? Well, they're not going to want financial planning from them either, right? So CFP determined that the best way to handle this is for the CFP professional to be able to continue to provide services. So here are the choices available to the CFP professional. You can not insert in the engagement. That's certainly a choice available to you. You can limit the scope of services. So, for example, if they want A, B, and C, and to do A, B, and C, you have to do financial planning. But if you just do A, you don't have to. Then you can limit it to just doing A and not provide financial planning. The third one, though, is one that comes up a lot. You could provide the services. You could provide A, B, and C, and explain to them the benefits of financial planning and what the limitations are on their services by not providing financial planning. If you do that, you can move forward without following the practice standards. And then finally, the choice that's available is to terminate the engagement. Those are the choices that are available to a CFP professional in that circumstance. All right, so the documentation requirement. Originally, in going through these standards, in one of its early drafts, we had throughout the practice standards, you must document this, document this, document this. And we looked at it and said, wow, that's a lot of documentation. If the CFP professional had to document all these things, you know, they're driving down the highway, a client calls and wants advice on something, you know the answer and you give it to them, you have to run back to your office, and no matter what it is, type it up. It's pretty burdensome on a CFP professional. So ultimately, we adopted a principles-based standard that says a CFP professional must act prudently in documenting information to act in the client's best interest. And there's factors to take into account. One is the significance of the information. The more significant it is, the more likely you need to document it. The need to preserve the information in writing, what does that mean? Well, that means if there's a trigger coming up, a trigger event in 3 or 4 months, where if the client doesn't do something, there's some serious consequences. Well, you need to have that in writing, because what if, you know, if we want to, this is hopefully would not happen, but if something were to happen to you, how would somebody who inherits the file after you know about that deadline? So the need to preserve the information in writing is a factor to be thinking about. The obligation to act in the client's best interest, that's a relevant factor. And also your firm's policy and procedures. You should be thinking about what your firm is requiring in that circumstance. So here are the practice standards. On the left is the current version. On the right is the new one. As you can see, there's been some adjustments. People talk about it going from 6 to 7. Do you know that, by the way, that we've gone from 6 steps to 7 steps? Does anybody know, by the way, why CFP Board now said there's 7 steps in the financial planning process, whereas previously we said 6? Anybody have any ideas on that in the Q&A box? All right, the answer is pretty straightforward. The reason that CFP Board changed its standards to have 7 steps is because CFP Board's Board of Directors believes that there are 7 steps in the financial planning process. That sounds a little silly, I know, right? You know, but that's exactly it. There were some people who wanted us to keep it as 6 steps because that's how it always had been. But CFP Board concluded that there are 7 steps, and so it broke them out that way. We moved one out of the practice standards that's giving the information to the client that remains in our standards, just in a different location. And then we took the remaining 5 and broke it out, turned them into 7 overall. That's the new 7-step process. You can see it here on the screen. The commentary goes through it in even greater detail. Okay, let's talk about the steps. So steps 1 through 3 are dealing with circumstances, goals, and options. So first of all, the very first step, understanding the client's personal and financial circumstances. That's really important. You can't help them if you don't know who they are. You have to obtain the qualitative and quantitative information. You have to analyze it, and you have to address the situation when there's incomplete information. Step 2 is to identify and select goals, identify potential goals, and then work with the client to select and prioritize the goals. Third step is to analyze the client's current and potential alternative courses of action. You have to analyze the current course and analyze those potential alternatives. Turn to the fourth step, which is developing the financial planning recommendation. You have to select the recommendations that are intended to maximize the client potential for meeting goals. And then for each recommendation, there's some things to consider: assumptions and estimates, the basis for the recommendation, the timing and priority, the interdependency of the recommendation. Is one recommendation dependent on the other? So the fifth one is presenting. As you know, the developing and presenting are one step of the current standards. CFP Board broke them out into new ones. That's because we believe these are different steps. As you may know now, a lot of people are working with teams where you have somebody developing the financial planning recommendation and somebody presenting it. So you have different people doing different things for different tasks. The presenting is to present the recommendations and present the information that were considered in developing the recommendations. That's what you do for presenting. 6 and 7 are implementing and monitoring. For implementation, you have to address implementation responsibilities, identify, analyze, and select actions, products, and services, then recommend the action, products, and services implementation, and then select and implement them. Monitoring progress and updating under our current standards, all we really say is you have to decide the monitoring responsibilities. We have a much more expansive standard that applies for monitoring. You have to monitor and update. First of all, you have to lay out what are the monitoring and updating responsibilities. Make sure everybody knows who's doing what. That's the first step. And then monitoring the client's progress. If you have the monitoring responsibilities, you have to analyze at appropriate intervals the progress towards achieving the client goals, and then review with the client the results of your analysis. Along the way, you need to update by obtaining current qualitative and quantitative information, and then update the goals, recommendations, or implementation decisions. If there's changes that are warranted to the, to those, then you must update as appropriate in accordance with the practice standards. All right, there's a lot in there, a lot of new content in the practice standards. I encourage you to read it because if you read it and understand it, it'll help you in delivering that content. So let's do a recap, a new definition of financial planning. Did anybody remember how many words in that definition? Anybody remember how many words there are in the new financial planning definition? That's right, 30. You got it right. That's exactly it, 30 words. A revised standard for determining when the practice standards apply. And then we also have updated steps for the financial planning process. So you'll have polling questions. We have 3 vignettes from which you may choose. And then you pick one, or, if you have time, pick 2. You have to decide how much time you have in your presentation. Put select a vignette, use it, blend it into your presentation. Hopefully you'll find that helpful. All right, everybody's favorite topic. Who loves disclosure? Not seeing many hands go up. It's something that's really important, though. Information that must be provided to the client. So with respect to providing information to a client, there are timing, delivery, and updating requirements, 8 categories of information, and if you're providing financial planning, there are additional requirements. So the timing of it, you have to do it prior to at the time of the engagement. Delivery, if it's financial advice, you don't have to do it in writing. That's true for everything but one thing. The privacy disclosure has to be in writing. Reg SP requires it to be in writing. So financial planning, you have to do it in one or more written documents. There's one exception there as well. That's material conflicts of interest. It's not required to be provided in writing, but the evidence of oral disclosure will be given such weight as CFP Board deems appropriate. So you should be thinking about, even if I'm not required to provide it in writing, when should I put it in writing as the best practice? Updating, there's an ongoing duty to provide the clients with a material change or update. And if there's an update to your disciplinary history or bankruptcy, 90 days is how much time you have to disclose that to the client. So here's the information that must be disclosed. It's on the screen. It's in the commentary. These are things that should be you should be aware of already because our current standards already really address these, but that's the list of information that must be provided. The terms of the engagement, this comes into play when you're providing financial planning. You have to provide the terms of the engagement. That includes the scope of the engagement, any limitations on the scope, when the services will be provided, and the client's responsibilities under the engagement. All right, quick review, information provided to clients. There's timing, delivery, and updating requirements. We have a vignette for this that you may want to use, and sharing that information with folks when you're doing your presentation. All right, here's a big one now. We're talking about recognizing and avoiding or disclosing and managing conflicts of interest. This is our 5th learning objective. Everybody awake out there still? We're almost at an hour. We've gone through 4 learning objectives. We're on number 5 now. And somebody was asking about the slides. So these slides you have, this is the slide deck for your delivery of your content. This is the slide deck you'll be using, so you'll have that available to you. And there are 2 ways you can do this. We are recording this program, so it'll be made available to folks who are delivering ethics CE content. But also Blaine Aiken and I. Blaine Aiken is the chair of the Standards Resource Commission. The CFP Board, I may have mentioned, is an organization. It's a professional body that works with members of the profession at all levels. So all of our volunteers at CFP Board come from the profession. We work together at CFP Board to benefit the profession. At the board of director level, most members of our board are members of the profession. We do have some because we're a 501c3 who are members of the public on our board. But that's the way it works throughout our volunteer bodies. We had formed a commission on standards to develop recommendations to our board about what the standards should be. 14 people, mostly members of the profession, also former regulators, consumer advocates. We've now formed what we call our Standards Resource Commission. These are people who are working with us to develop compliance, guidance, resources. We have, again, 14 people who are working on that. These are people who come from all areas of the profession. We've already developed quite a bit of guidance. More is on the way. That's something you should be aware of that's in place right now. And then one other thing I wanted to mention to you while I have your attention is that CFP Board is a standard setting and enforcement body. We have standards that we enforce. We have an enforcement process. We have another group of professionals who are involved in deciding when there's been a violation of CFP Board's ethical standards. We call that our Disciplinary and Ethics Commission. These are folks just like yourself who are members of the profession. People come in to work with that commission to help them determine whether there's been a violation, and if so, what the consequences should be. So this is an opportunity that's available to you if you're interested to think about doing it. We have an application form that we use. My name is Leo Rajeski. Again, if you want to be interested in that, let me know. But it's an opportunity to get involved at CFP Board. You would come for 3 days where you'd be reviewing the factual background, working with the decision makers to think through the issues, making recommendations, and engaging in deliberative dialogue to decide those issues. So if you're interested in doing it, we'd love to hear from you. Again, you'd be a volunteer working with CFP Board's Disciplinary Ethics Commission. It's just another way in which you can get involved with the profession, a way in which you get involved with CFP Board. Okay, so now let's get back to the conflicts of interest. This is a big area. As I mentioned before, one obligation, one way to do it, you can just avoid conflicts of interest. You don't have the conflicts, you don't have to disclose or manage them. So that's one way to deal with it. But most CFP professionals have conflicts. The most basic conflict you have is if you're being compensated. You may be getting compensated based on assets under management. You may be charging a flat fee. You may be compensated through product sales. There's different ways that you're compensated. you have to disclose, that conflict to your client. You have to obtain informed consent, and then you also have to manage the conflict in the client's best interest. That's the basic summary of the obligation, but let's work our way through it. So the disclosure obligation is to fully disclose all material conflicts of interest that could affect the professional relationship. So we have some terms in there that are important terms, like conflict of interest. So a conflict of interest exists where the interests of the CFP professional and the firm are adverse to the interests of the CFP professional's duties to the client. All right, so you're getting paid. The client's paying for it one way or the other. So those interests are adverse. The more you make, the more they're paying. There's an adversity of interest in that front. But there's another way a conflict can emerge is when a CFP professional has duties to one client that are adverse to another client. Does anybody here have any ideas or any examples of when that second type of conflict emerges? All right, yeah, somebody got it right. Somebody out there got it right. It's a divorce, right? You could be representing a married couple, and the number one cause of divorce, by the way, is marriage. Leading cause, leading indicator of divorce is marriage. So, I think now the percentages in America, it's close to 50%, right? You're trying to know the percentage. It's pretty high. So that happens sometimes. Couples married, things don't work out, they get divorced. You're representing both clients, husband and wife. Then you have to deal with that situation where they have an adversity of interest. You have a conflict because, the married couple now going through divorce has issues. Material, so conflicts of interest. What's material? It's when would a reasonable client or prospective client, when would they consider the conflict of interest important in making a decision? That's what a materiality is. It's a principles-based definition. So the obligation here is to disclose sufficiently specific facts. Would a reasonable client understand the conflict and how it could affect the advice? That's the test for determining whether you provided sufficiently specific facts. Ambiguity in the way you've described it, that's going to be interpreted in favor of the client. In other words, you're the one providing that to the client. You have an obligation to make it clear to the client. How do you deliver conflict information? Well, written disclosure is not required. CFP Board did not require you to do it in writing. You can do it orally. However, oral disclosure is weighed as CFP Board deems is appropriate. That's really just, an indication that the more significant the conflict, the more prudent it would be to document that conflict and provide that to the client so that they're aware of it. But again, that's the best practice. We don't require it to be in writing. And obtain informed consent. We do not require written consent back from the client. Consent also can be inferred, so you provide the information to the client moves forward. There are circumstances when you can just infer that consent based on silence. Managing conflicts. So again, you go from material conflict to disclosing, obtaining informed consent, and then managing it. Management of conflicts means adopting and following business practices that are reasonably designed to prevent those conflicts from compromising the CFP professional's ability to act in the client's best interest. In other words, having a useful process for handling conflicts is an important way of managing them. Quick review. So you have to disclose material conflicts of interest, obtain informed consent, and then manage the conflicts. Those are the elements here. Once again, we have provided polling questions. We have provided vignettes that you may use. We have several examples here for things you might want to consider using. They're available for you to use. Please do take a look at them. And that's it. We've gone through 5 learning objectives. We've covered a lot of material today. My door is always open for a conversation to talk about any of this. Alex, why don't I turn it back to you, because maybe there's some things that you might want to address with the group.
Okay, first, actually, let's see if the group has any additional questions. So we'll just take a couple minutes here and type in your questions, and we'll see if we can get a few of them answered.
Hey, so Ralph asks about, do you have any language that might be helpful to accompany the slides? So you should know that the slides we provided, Alex, everybody has that slide deck, right?
I believe so.
There are comments to them at the bottom, and the comments do walk through language you should consider. I wouldn't necessarily say it's a script. Ralph, I think you should try and make it comfortable for you, but I think there's language that you could draw from that would be helpful to you, hopefully, in delivering the presentation. Jocelyn wants to know contact info. If you're referring to my contact info, my number is 202-379-2230. Or if you like, an easier way to get in touch with the CFP Board, because I do have a team of people working with me. They're all highly competent. You could type in compliance@cfpboard.org. We have people monitoring that email box. Quite candidly, it's much better for you to email that address than mine. I'm oftentimes out of the office doing things. But if you go to the compliance@cfpboard.org, we have people there who are responsible for monitoring that box and getting back to you in a timely manner.
And also, if it's just for specific CE sponsorship questions, just do cesponsor@cfpboard.org. All right. Well, thank you so much for your questions. The next steps really are for you to complete the instructor attestation, pass the background check, prepare your presentation, and once you pass the background check, you'll be an approved ethics instructor. Thank you again for your time today. Please feel free to reach out to, again, cesponsor@cfpboard.org with any CE-related questions, and reach out to compliance@cfpboard.org with any questions related to the new code and standards. Have a great day.